All rise, we will lever. The International Criminal Court is now in session. Lord John de Coup Panel International at OIT. Please be seated. We will swear.
À tout le monde à l'intérieur, à l'extérieur.
Good morning. I would like to welcome everyone, both inside and outside of the courtroom. I shall start by asking the court officer to kindly read out the case, please.
Good afternoon, Madam President, Your Honors. Situation in Libya in the case of the prosecutor versus Khaled Mohamed Ali El Hishri, case reference ICC 0111-0125, and for the record, we are in open session.
Judge Motoch, thank you very much. And I will now ask for the appearances from the parties. Please kindly observe a pause before you speak and endeavor to speak slowly in order to facilitate the work of our interpreters. I shall begin with you, Madam Deputy Prosecutor.
Your Honours, I'm Nazat Shamim Khan, Deputy Prosecutor, and I appear with the prosecution team today.
Merci beaucoup.
Judge Motoch, thank you very much. And the floor goes to the Defense Counsel.
شكرا سيدة الرئيس.
Thank you, Madam President. Thanks for the respected panel. My name is Yasser Hassan. I am here representing on behalf of the defense of Mr. Al-Hishri, with me, Mr. Ian Edwards, in the defense team. Thank you.
Merci, maître. Je me tourne maintenant vers les représentants du greffier.
Je vous remercie, Madame la
Mr. Dubuisson, thank you, Madam President, Your Honors. My name is Marc Dubuisson, Director of Judicial Support Services in the Registry, and I replace Osvaldo Zavara. And I am accompanied by the coordinator of judicial services and the chief of the detention center. Judge Motoch, thank you for my part. I will now introduce the chamber. First of all, the Vice President of the Court, Judge Adelaide Sophie Alpanit Gansu and Judge Maria del Socorro Flores Liena. I am Julia Antonella Motoch. I'm the presiding judge of the pretrial chamber 1. And at this point, I would like to address myself directly to you, Mr. El Hishri. Please kindly stand up.
Je voudrais tout d'abord
I would like to begin by confirming your identity. Could you please state your name?
Khaled Mohamed Ali Al-Hishri.
quelle est votre date de naissance?
And what is your date of birth?
Quel est votre lieu de naissance?
Where were you born?
Quel est votre lieu de naissance?
Where were you born?
23rd of June, or 23rd of June 1978 in Tripoli.
À titre préliminaire, il est utile.
You may now be seated. By way of introduction, it is important to clarify the nature and limited scope of this first appearance. Today's hearing is neither the commencement of trial nor of the confirmation of charges. In the course of the hearing of today, evidence shall neither be adduced nor presented, and any matters relating to the guilt or innocence of Mr. El Hishri shall not be touched upon. pursuant to Article 61 of the Rome Statute and to Rule 121 of the Rules of Procedure and Evidence, the principal objective of this first appearance hearing is to provide answers to 3 questions. Firstly, the Chamber shall satisfy itself that the person subject to the arrest warrant has been informed of the crimes which he or she is alleged to have committed. Secondly, the Chamber shall satisfy itself that the person has been informed of his or her rights under the Rome Statute. Thirdly, the Chamber shall set the date on which it intends to hold a hearing to confirm the charges. In relation to point 1, I would like to recall that Mr. Hishri has received a copy in Arabic of the arrest warrant in his name, and that a redacted version of the application of the Office of the Prosecutor for the issuance of the arrest warrant is now in the public domain. That said, I would like to ask the court officer to please read out the charges filed against him, and she will do so in English. Madam Court Officer, you have the floor.
On 10 July 2025, Pre-Trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. El-Hishri is criminally responsible pursuant to Article 25(3), subsection A and B of the Rome Statute, for the following alleged war crimes committed in Libya in or near Mitiga prison against detainees from around February 2015 to at least early 2020. Cruel treatment under Article A2, subsection C, Roman 1 of the statute, by inflicting severe physical or mental pain or suffering upon at least a few persons protected by Common Article 3 to the 1949 Geneva Convention. Torture under Article A2C, Roman 1 of the statute, by inflicting severe physical or mental pain or suffering upon at least a few persons protected by Common Article 3 to the 1949 Geneva Convention for the purpose of obtaining information or a confession, punishment, intimidation, or coercion under Article A2, subsection C, Roman 1 of the statute. Murder under Article A2, subsection C, Roman 1 of the statute, committed by killing at least a number of persons protected by Common Article 3 to the 1949 Geneva Convention. Outrages upon personal dignity under Article A2C, Roman 2 of the statute, inflicted by humiliation, degradation, or otherwise violation of the dignity upon at least a few persons protected by a Common Article 3 to the 1949 Geneva Convention. Rape under Article A2, subsection E, Roman 6 of the statute, of at least 2 persons who were protected under international humanitarian law at the time. Sexual violence, Article A2, subsection E, Roman 6 of the statute, committed against at least 2 persons protected under international humanitarian law. Furthermore, the Chamber found that there were reasonable grounds to believe that Mr. El-Hishri is criminally responsible also pursuant to Article 25(3), subsection A and B of the statute, for crimes against humanity committed against certain persons detained in Mitiga prison. These crimes against humanity that will be read out next were allegedly committed as part of a widespread or systematic attack against segments of the civilian population in Libya, who were perceived to be opposing SDF, RADA, or its ideology, pursuant to a state or organizational policy. Imprisonment, under Article 7.1, subsection E of the statute. Torture, under Article 7.1 F of the statute. Rape of at least 5 persons, under Article 7.1G of the statute. Sexual violence, under Article 7.1G of the statute. Murder, under Article 7.1A of the statute, by intentionally killing one detainee himself and being responsible for the killing of a significant number of other detainees. Persecution, Article 7.1H of the statute, by targeting detainees on the basis of inter alia their views.
Merci beaucoup.
Thank you very much, Madam Court Officer. You have just listened to a reading of the charges which are in line with the contents of the arrest warrant that you have previously received. This means that you have been informed of the crimes which you are alleged to have committed, and that brings us to the end of the first point as indicated above. I will now move on to the second point, which sets out your rights as a suspect before the court. I will read out a recapitulation of some of those rights which are of crucial importance at this stage of the proceedings. They are as follows. You may benefit from the assistance of a competent interpreter free of any cost, as well as such translations as are necessary to meet the requirements of fairness. You have the right to have adequate time and the facilities necessary for the preparation of your defense, as well as the right to communicate freely with counsel of your choosing in confidence. You have the right to remain silent, and you cannot be compelled to testify against yourself or to confess guilt. You may also make unsworn statements in your defense. In addition to any other disclosure provided for by the statute, the prosecutor shall, as soon as practicable, disclose the evidence in its possession or control which shows or tends to show innocence or to mitigate your guilt, or which may affect the credibility of prosecution evidence. At the confirmation of charges hearing, you may object to the charges, challenge the evidence provided by the prosecutor, and present evidence of your own. You shall not be committed to trial if the charges against you are not confirmed or if the proceedings against you are discontinued. You have the right to be informed promptly and in detail of the nature, cause, and content of the charges in a language that you fully understand and speak. And lastly, Mr. Hishri, you have the possibility of applying for release pending trial. We received an email this morning indicating that they had submitted an application for provisional release. We have taken note, and it should be filed on record in written form so that the chamber can render a decision in due course. Do you have any observation to make?
My counsel.
Thank you, Your Honor. He has no response.
Ouais. Merci beaucoup, maître. Vous pouvez vous asseoir.
Thank you, counsel. You may now be seated.
Je vous demande maintenant, Monsieur Al-Hishri, si vous avez des observations.
Mr. Hishri, at this juncture, I would like to ask you whether you have any observations to make in relation to the conditions of your detention at the detention center of the court or of your transfer to the court.
Your Honor, the Arabic language does not exist.
Let me repeat, says Judge Motoch.
But you speak French, Your Honor, and he need to hear from an Arabic language.
Bien sûr.
Judge Motoch, of course, I will now speak slowly. At this juncture, Mr. Hishri, I would like to ask you, do you have any observations to make in relation to the conditions of your transfer to the court or to the conditions of your detention at the detention center of the court in The Hague from the moment of your arrival there?
Just requesting my release.
Je vous remercie, Monsieur Al-Hishri. Vous pouvez vous rasseoir.
Judge Motoch, thank you, Mr. El Hishri. Please be seated. You can now be seated.
Je vais à présent fixer la date de l'audience.
I shall now set a date for the confirmation of charges hearing. After having assessed all the relevant factors, including the necessity for the parties and participants to prepare themselves adequately and mindful of the rights of Mr. El Hishri, the date for the commencement of the confirmation of charges is hereby set on the 19th of May, 2026, in order to enable everyone concerned to smoothly navigate the upcoming stages of the proceedings. I will lay down some guidelines on behalf of the Chamber. The Chamber shall conduct a number of status conferences to ensure that the exchange of information inter parties is carried out seamlessly and adequately. The first status conference is slated for either the 28th or the 29th of January 2026. A detailed agenda thereof shall be issued in due course. The prosecutor must, as of today, begin the disclosure of any and all information or materials based on which the arrest warrant was issued, and such disclosure should be completed by the 11th of December 2025. It is the opinion of the Chamber in this case, and in accordance with Rule 81, paragraphs 2 and 4 of the Rules of Procedure and Evidence, that it is necessary to implement the redactions protocol set out in paragraphs 91 to 100 of the latest edition of the Chamber's Practice Manual. With regard to the time frame and format for the disclosure of evidence and related matters, the Chamber instructs the parties to consult with each other and to submit filings containing concrete and joint proposals to the extent practicable by the 15th of January 2026. Such filings may deal with any other matters that the parties would like to have included on the agenda of the first status conference. The Chamber is of the view that it would be appropriate to adopt the protocol on the handling of confidential information during investigations and contacts between a party or a participant and witnesses of the opposing party or of a participant as laid down in the annex of the latest version of the practice manual. Drawing from the settled practice of the chambers of the court, we believe that it is appropriate in this case to adopt the procedure for admission of victims to participate in the proceedings in accordance with the ABC approach articulated in paragraph 96, as well as the time frame stipulated in paragraph 97(1) of the practice manual. The registrar may use either the standard form or the form designed for applicants living under the same roof. Lastly, for the purpose of the organization of the common legal representation For the victims, the Chamber instructs the registrar to submit filings setting out any recommendations deemed to be useful for such organization by the 17th of December 2025. Any responses to such filings must be submitted before the 19th of December 2025. We have now come to the end of our hearing. I would like to thank all the participants, the security officers, the audiovisual team, as well as the interpreters and court reporters. This hearing is now adjourned.